If you've got a specific legal question or situation you'd like to see covered here, drop it in the comments, because that's genuinely where a lot of future topics come from. I read them, and some of the most useful specific videos on this channel started as exactly that kind of comment from someone dealing with a real situation, so don't hesitate. Whatever it is, I'd like to hear it. All right, let's keep moving. You're driving home, normal Tuesday. Maybe you stopped to grab something to eat. Maybe you took the long way because traffic was bad. Maybe you've got music on and you're not thinking about anything at all. You pull into your driveway, get out of your car, and as you're walking toward your front door, you notice a police cruiser parked on the street in front of your house. Not lights, not sirens, just sitting there, engine off, officer inside. And then the officer gets out, walks toward you, and says something you've heard before in movies and TV shows and true crime podcasts, but never quite expected to hear, aimed directly at you. I'm going to be honest with you. I smell something, and I'd like to take a quick look around. And in that exact second, something happens inside most people that I want to talk about before we get into a single legal principle, because it matters as much as anything else in this video. Most people go completely blank. Not because they're guilty of anything, not because there actually is anything to find, but because nobody ever sat them down and explained what that sentence actually means legally, what rights it does and doesn't trigger, and more importantly, what 3 words you need to know before you say anything else, before you agree to anything, before you take a single step toward your own front door with an officer behind you. And that gap between what people feel in that moment and what they'd feel if they actually knew the framework, that gap is exactly what this video is designed to close. If you want to know your rights in situations like this, instead of improvising under pressure and hoping the instinct you were born with happens to match what the law actually says, subscribe right now, because that's the specific thing we're here to walk through, one real scenario at a time. Quick note before we start. Everything here is legal education and general commentary, not legal advice tailored to your specific situation, and some details vary by state, but the core principles we're covering hold up in the overwhelming majority of places in this country. Now let's get into it properly. Let's start with what "I smell something" actually means legally, because the phrase itself carries a lot of weight in search and seizure law, and most people have no idea why. When an officer says they smell something, what they're doing, legally, is asserting the existence of a sensory observation that they believe, or claim to believe, gives them what's called probable cause. Probable cause is the legal standard that allows a search to happen without your consent. It's a lower bar than the standard you'd need to convict someone of anything, but it's supposed to be a real bar, a genuine reason to believe that evidence of a crime is present in a specific place. When an officer invokes smell, and specifically when they invoke the smell of marijuana, which is the context this comes up in most often, they're claiming that this sensory observation by itself crosses that bar, that it's enough justification on its own to search your vehicle, your home, your person, depending on where this is happening. And here's where it gets genuinely complicated and genuinely important to understand, because the law on this specific question is not the same everywhere in this country right now. I want to talk for a second about why I think content like this actually matters, beyond just being interesting to talk about. There's a real meaningful gap between people who have easy access to legal knowledge, whether through education, profession, or family background, and people who don't, and that gap has real consequences in real situations. It's not fair, and it's not something any individual video is going to fully fix, but I do think there's genuine value in narrowing that gap even a little, one plain language explanation at a time, for anyone willing to spend a few minutes actually learning something instead of relying on guesswork or half-remembered fragments picked up secondhand. That's the actual mission behind this, as unglamorous as that sounds, not to turn anyone into a lawyer, but to close the specific, practical gaps that leave ordinary people at a disadvantage in moments that matter. All right, let's keep working on exactly that with today's topic. Now, and the reason it isn't is something that's been shifting dramatically over the last decade. As more states have legalized marijuana in some form, medical, recreational, or both, the question of whether the smell of marijuana constitutes probable cause for a search has been actively reconsidered in court after court, in state after state, in ways that have produced genuinely different answers depending on where you are. In some places, courts have held that the smell of marijuana still constitutes probable cause even after legalization, on the theory that even legal marijuana can't be consumed in certain ways, can't be possessed in certain amounts, and that the smell alone doesn't establish whether what's present is a legal or illegal quantity or use. In other places, courts have gone the other direction entirely, holding that in a state where marijuana is legal, the smell of it is no more evidence of criminal activity than the smell of alcohol or cigarettes, and that treating it as probable cause is no longer a defensible position post-legalization. In still others, the question is actively being litigated right now, with different courts giving different answers even within the same state. What this means for you practically is that the phrase, "I smell something," is not a magic key that automatically unlocks the right to search you, and it's not a legal phrase with one fixed, settled meaning that applies everywhere. What it is a claim being made by an officer in a specific jurisdiction with a specific legal framework around exactly this question, and knowing where your jurisdiction falls in that framework is genuinely valuable information worth having before you need it. We'll come back to how to find out exactly where your state stands in a moment, but first, let's talk about the 3 words you need to know before you respond to anything, because this is the center of everything this video is built around. The 3 words are these: am I free? As in, am I free to go? Or in a home context, am I free to leave? Or even more specifically, in the scenario we opened with, where an officer is standing between you and your own front door claiming to smell something, am I being detained? Those 3 words, and specifically that last version of them, do more work in this exact scenario than almost any other sentence you could say, because the answer to that question determines which of 2 completely different legal frameworks applies to everything that happens next. Let's break down why those words matter so precisely, because the logic here is important, and I don't want to just hand you a phrase without explaining why it's the right one. When you encounter an officer and they begin talking to you, that interaction can be one of 2 fundamentally different things from a legal standpoint. It can be a consensual encounter, meaning a voluntary conversation that you're fully free to walk away from at any time, the same way you're free to end a conversation with a stranger on the street. Or it can be a detention, meaning the officer has decided, based on some articulable suspicion, to temporarily hold you in place while they investigate something specific. The difference between these 2 categories is enormous, because a consensual encounter requires no legal justification and you have no obligation to participate in it, while a detention requires the officer to have what's called reasonable suspicion that something criminal is happening or has happened. Reasonable suspicion is a lower bar than probable cause, but it's still supposed to be a real bar, not a hunch, not a feeling, not a general sense, a specific, articulable reason to believe criminal activity is involved. When you ask, "Am I being detained?" you're forcing that categorization to happen explicitly and out loud, right now, in front of both of you. Either the officer says no, in which case you know you're in a consensual encounter, and you're free to politely decline to continue it. Or the officer says yes, in which case you know you're being detained, and everything that follows is governed by the rules around detention, including the requirement that the officer eventually articulate their basis for it. There is no third option. Am I being detained doesn't give the officer a way to keep you in a vague, undefined middle space where it's unclear whether you have to stay, because that middle space is exactly what makes people feel like they can't decline, can't walk away, can't assert any rights at all without things getting worse. Let me walk through what the 2 possible answers to "Am I being detained?" actually look like in practice, because this is where the framework becomes genuinely useful. If the officer says no, you are not being detained, then what you have is a consensual encounter, and you can say, calmly and respectfully, "I appreciate that, and I'd rather not continue this conversation right now. I'm going to head inside." And then you do exactly that. You do not run. You do not hurry. You walk normally, at a normal pace, toward your door, and if the officer does not actively stop you, that encounter is over. You've done nothing illegal, nothing suspicious, nothing that creates any kind of problem for you, because declining to participate in a voluntary conversation is fully within your rights and cannot, by itself, be treated as evidence of anything. If the officer does try to stop you after telling you you're free to go, that creates a whole different set of legal questions that you'll want an attorney to look at carefully, because you've now created a clear record that you asked, they said yes, and they stopped you anyway. If the officer says yes, you are being detained, then you have a different situation on your hands, and I want to walk through it carefully, Being detained means you're legally required to stay in place, and it means the officer has, at least in their own mind, a reason for detaining you. This is the moment where the second critical phrase matters, and it's this: I don't consent to any search. Say it calmly, say it clearly, say it once, and then stop talking. I don't consent to any search. Not a fight, not an argument, not a raised voice. Just a clear, calm statement of a legal position that is entirely yours to take and that costs you nothing to assert. Because here's what most people don't understand about why consent matters so much even after a detention has been declared. A detention doesn't automatically authorize a search. The legal standard for detention is reasonable suspicion, which is lower than probable cause, which is the standard required for a search. Being detained does not mean you've consented to a search, and being told, I smell something, does not, in every state and every legal context, automatically clear the bar for probable cause. Saying, I don't consent to any search, puts on the record, clearly and explicitly, that any search that happens from that point forward is happening over your objection, not because you agreed to it, and that distinction matters enormously if this situation ever ends up in front of a judge. Now here's the question I know is forming in your mind right now, because it's the question everyone asks at exactly this point in the conversation, and it's a fair one. If the officer says they have probable cause based on the smell, aren't they going to search regardless of whether I consent or not? And the honest answer is, possibly yes. If an officer genuinely has probable cause, they can conduct a search without your consent. But there are two things happening when you say, I don't consent, even in that situation, and both of them matter. The first is that you're preserving your ability to challenge the probable cause claim later. If it turns out the smell claim was overstated, fabricated, or legally insufficient in your jurisdiction given the current state of marijuana law, saying, I don't consent, is part of what allows your attorney to make that argument effectively afterward, because it establishes clearly that you never handed over your Fourth Amendment rights voluntarily, and any evidence found in the search can potentially be challenged on that basis. The second thing that happens when you say I don't consent is that you're drawing a clear line around the scope of what's happening. A consent search and a probable cause search have different rules around scope and execution, and having a clear record that you did not consent to anything is part of what prevents a conversation that starts with I smell something from quietly expanding into a complete, consent-based turning out of your car, your home, and your entire life based on your own voluntary cooperation. Let's talk specifically about the car context, because the scenario we opened with, officer approaching you as you get out of your car in your own driveway, sits at an interesting intersection between your vehicle and your home, and that intersection has legal significance worth understanding. Your car does not carry the same level of Fourth Amendment protection as your home. We've talked about this in other contexts, and it's worth restating specifically here. Courts have long recognized an automobile exception to the warrant requirement, meaning that if an officer has probable cause to believe a vehicle contains evidence of a crime, they can generally search that vehicle without a warrant. Because vehicles are mobile, because the expectation of privacy in a vehicle is considered lower than in a home, and because the courts decided a long time ago that waiting for a warrant while a vehicle could be driven away is impractical. This is why I smell something coming from an officer next to your car hits differently, legally, than the same claim made at your front door. Near your car, the claim is operating in a legal environment where the automobile exception applies, and the probable cause bar, if cleared, can justify a search without a warrant. But if the interaction is happening as you're walking toward your front door, or if officers are suggesting that the smell justifies going into your home, the legal framework shifts dramatically, because your home carries a fundamentally different and far stronger protection, and the smell claim alone does not, without more, authorize entry into your residence, the way it might authorize a search of your vehicle in a jurisdiction that still treats it as probable cause. This is exactly why, if you're in a situation where an officer at your driveway is suggesting they want to follow up this smell claim by coming inside, the third critical phrase comes in: I don't consent to entry into my home. 3 things, all calm, all clear, all said in a normal tone of voice. Am I being detained? Followed, if yes, by I don't consent to any search. Followed, if they move toward your door, by I don't consent to entry into my home. 3 phrases, each one doing specific, targeted legal work in a specific, targeted moment. Let's go through each one more time, because I want the logic to be crystal clear before we move forward. Am I being detained? forces the categorization of the encounter. It eliminates the vague middle space. It requires the officer to tell you, explicitly, whether you're in a voluntary conversation you can walk away from or a legal detention that has its own rules and requirements. It is not aggressive. It is not hostile. It is a direct, factual legal question that you are fully entitled to ask and that produces genuinely useful information about your situation the moment it gets answered. I don't consent to any search preserves your Fourth Amendment rights in a form that can actually be used later. It does not guarantee that no search happens. Probable cause, if it genuinely exists, allows a search without consent. But it ensures that any search that does happen is happening over your explicit objection, which is legally significant in ways that your silence or ambiguous non-response simply is not. Courts distinguish between a search conducted with consent and a search conducted over someone's objection, and that distinction can be the difference between a piece of evidence being admissible and it being suppressed. I don't consent to entry into my home invokes the specific, elevated protection that applies to your home and does not apply to your car. It draws the line at your front door, explicitly, on the record. It means that if an officer does enter your home after you've said this, any question about whether they had legal authority to do so, a valid warrant, genuine exigent circumstances, something other than just your voluntary consent, is preserved and available to be argued by an attorney, because you've made clear that your consent was never given. Now let's slow down and spend some real time on the probable cause question specifically, because this is the part that's changed most dramatically over the last decade, and where the gap between what people think the law says and what it actually says has gotten the widest. The traditional legal position on marijuana smell was fairly simple. Trained law enforcement officers are considered capable of recognizing the smell of marijuana, and the presence of a controlled substance is evidence of criminal activity. Therefore, the smell constitutes probable cause for a search. This was a workable, straightforward rule when marijuana was uniformly illegal everywhere, but it was built on an assumption that's no longer true in a large chunk of the country, which is the assumption that the presence of marijuana smell necessarily indicates criminal activity. Here's the problem that legalization has created for that traditional rule, and it's a real problem that courts have been wrestling with in very different ways. If marijuana is legal in your state, recreationally, medically, or both, then the smell of marijuana is not necessarily the smell of illegal activity. It might be the smell of something purchased legally from a licensed dispensary, consumed in a legal context by an adult who has every right to have it. The mere presence of the smell tells you nothing about whether what's present is legal or illegal, within legal limits or over them, possessed lawfully or unlawfully. The smell, standing alone, has become ambiguous in a way it never was before legalization, and some courts have recognized this explicitly and changed the law accordingly. In states like New Jersey, courts have held that the odor of marijuana alone no longer justifies a warrantless search post-legalization. In Illinois, the same conclusion has been reached in various forms. In other states, courts have gone the other way, maintaining that the smell still justifies a search because the details of legal versus illegal use still give police something to investigate. And in still others, the legislature has stepped in to address it directly, either codifying that the smell is not sufficient or explicitly preserving it as probable cause. What this means for you is something genuinely practical. Knowing where your specific state falls on this specific question is genuinely valuable information, and it's worth spending 20 minutes finding out. Search your state plus marijuana smell probable cause and read what comes up, particularly anything from state appellate courts in the last 5 years, because that's where the actual operative rule is being made. What you find might surprise you. In some states, the traditional rule is completely unchanged. In others, the rule has shifted so significantly that an officer invoking smell as their basis for searching your car is, legally speaking, standing on very thin ice, and saying, "I don't consent to any search," combined with later challenging the probable cause claim could be genuinely, practically effective in court. Let's talk about what you should and shouldn't say beyond these 3 phrases, because the temptation to keep talking in these situations is one of the most consistent ways people make their own situations harder than they need to be. The biggest mistake people make after saying, "I don't consent to a search," is immediately following it with an explanation. "I don't consent to a search because I know my rights and there's nothing in there anyway. I haven't done anything wrong. I just got back from my friend's place where some people were smoking but I wasn't, and I've got a prescription for something that might smell similar." Every sentence after "I don't consent to a search" in that string is potentially giving the officer useful information that goes well beyond what they already had. You've now told them where you were, that there was marijuana present near you, and that you're worried about something that might smell similar. You haven't helped yourself. You've made the officer's probable cause argument significantly easier than it was before you started talking. The phrase, "I don't consent to any search," is complete. It doesn't need a because. It doesn't need an explanation. It doesn't need a disclaimer about how you have nothing to hide. It stands entirely on its own, and adding to it typically only creates problems rather than solving them. If the officer pushes back, asks why, says if you have nothing to hide, you should be fine with this, and this is extremely common. It is a standard conversational pressure technique. You can simply say, "I understand, and I still don't consent to a search." That's the full response. The reason you don't consent doesn't need to be explained, doesn't need to be justified, and doesn't need to be defended. Declining a consent search is like declining to answer questions. It's a right you have, and exercising a right doesn't require an explanation any more than invoking the Fifth Amendment requires you to explain why you're invoking it. Let's talk about the pressure tactics specifically, because they're real, they're common, and understanding them in advance is what makes them ineffective, rather than convincing in the moment. If you have nothing to hide, you'd let us look. This is probably the single most common thing officers say when consent is declined, and it works as a pressure tactic, specifically because it frames refusing a search as inherently suspicious. But there are two things deeply wrong with this framing. The first is that the entire point of the Fourth Amendment is that you don't have to have something to hide in order to have privacy rights. Privacy isn't a perk you earn by being innocent. It's a fundamental protection that exists for everyone, innocent and guilty alike. Specifically so that the government has to meet a standard before entering your life, rather than just asking nicely and making you feel suspicious for saying no. The second is that this logic, if applied consistently, would eliminate the concept of constitutional protection entirely. If you only get to have rights when you have something to hide, then rights don't exist in any meaningful sense, because someone always has to have something to hide for the protection to apply, and nobody ever thinks of themselves as being that person. This will only take a minute. This is a minimization tactic, and it's designed to make the cost of compliance seem trivially small so that saying yes feels easier than saying no. But the length of a search is not the thing that matters legally. A 60-second consent search that finds something is exactly as legally significant as a 3-hour one. The amount of time it takes is not the question. The question is whether you're consenting to a search that you're not required to consent to, and the answer to that question doesn't change based on how quickly the officer promises to complete it. We can do this the easy way or the hard way. This is a more direct pressure tactic, designed to make non-consent sound like choosing conflict rather than choosing your rights. But the easy way and the hard way, in this framing, both involve an officer searching something you haven't given them legal justification to search without your consent, and the difference between them is entirely about how you feel in the moment, not about anything that's legally different between the two outcomes. If the officer genuinely had probable cause independent of your consent, they'd be searching, not negotiating. If they're negotiating, trying to persuade you to consent, that's a signal that your consent is what they're actually relying on. We're going to get a warrant anyway. This is actually, in some ways, the least concerning thing an officer can say in this situation, because if they genuinely had the basis for a warrant, getting one is the right path for them to take, and a judge, rather than a doorstep conversation, is the appropriate person to decide whether the legal standard has been met. Saying "that's fine, I'll wait for a warrant," is a completely reasonable response to this claim, and it means that a neutral, independent third party, the judge signing the warrant, will have to review whatever evidence the officer is relying on before any search happens. That is exactly how the system is supposed to work. A judge reviewing probable cause and signing a warrant is a meaningful check on exactly the kind of claim that starts with, "I smell something." Encouraging that process to happen, rather than short-circuiting it with your consent, is genuinely to your benefit. Let's talk about the warrant scenario in the smell context specifically, because it comes up and it's worth understanding what happens if an officer does leave to get a warrant after you've declined consent. If an officer does obtain a warrant based partly on a smell claim, that warrant will still need to meet the legal standard for probable cause, and that standard, as we discussed, is changing in some states specifically around marijuana. If you've declined consent clearly, If the officer goes and gets a warrant, and if a search is then conducted pursuant to that warrant, your attorney will have the opportunity to challenge whether the warrant was validly issued, whether the probable cause was actually sufficient in your jurisdiction given current law, whether the smell claim alone or combined with other factors actually crossed the bar. This challenge is called a motion to suppress, and it's the specific legal mechanism designed to ensure that evidence obtained through a constitutionally defective search cannot be used against you. Your consent or refusal earlier in the encounter matters enormously to this process, because a consent search generally can't be challenged the same way. By consenting, you've arguably given up the very protection that would allow evidence to be thrown out later. By declining consent and creating a clear record of your refusal, you've preserved that challenge for exactly the setting designed to evaluate it properly. Let's talk about what to do with your body during this whole interaction, because physical behavior matters in ways that aren't always obvious. Keep your hands visible at all times. Not raised, not dramatic, just visible. If you're getting out of your car, don't reach back in for anything after the officer has approached. If you need to get something, your phone to call someone, your wallet, anything, tell the officer what you're doing before you do it. I'd like to reach into my pocket to get my phone. This isn't about being submissive. It's about ensuring that nothing you do physically gives rise to any claim that you were behaving in a way that created safety concerns, because those claims, even if you know they're not accurate, create complications that can distract from the actual legal questions you want to stay focused on. Don't make any sudden movements toward the officer, obviously, but also don't make sudden movements away from them. If you're declining to answer questions and exercising your right to walk toward your door, do it calmly, at a normal pace, in a straight line. Don't look over your shoulder repeatedly. Don't change direction abruptly. Don't speed up if they call after you. Calm, deliberate, normal movement is both practically useful, it doesn't escalate anything, and legally useful, because it makes clear that your physical behavior was completely normal and gave no independent basis for anything beyond what the officer had already articulated. Stay calm in your voice. This is worth saying explicitly, because it's harder than it sounds when adrenaline is involved. Your voice is going to want to do things in this situation. Get higher, get faster, get defensive, get argumentative, and all of those vocal patterns can make a clear, simple statement of legal position sound like either panic or aggression, neither of which helps you. Slow your breathing deliberately if you need to. Speak at a measured, normal pace. If you have to pause to remember the right phrase, pause. "Am I being detained?" said slowly and clearly after a brief pause is far more effective and far less likely to produce a defensive response from the officer than the same phrase said in a rushed, anxious rush. Let's talk about documentation, because this matters here exactly as much as it does in any other interaction with law enforcement. If you have a phone accessible, and in many situations you will, you're generally allowed to record your interactions with police performing public duties, including interactions that happen in your driveway or at your front door, though the specific rules around recording vary, and it's worth knowing your state's approach. Even if you're not actively recording, make a mental note of the specific time the interaction started, the approximate number of officers present, any badge numbers or names you can catch, and most importantly, the exact language the officer used when they claimed to smell something. Did they say, "I smell marijuana" specifically? Did they say it was coming from your car, your person, your yard? Did they describe it as strong, faint, fresh? These details matter because the legal question of whether the smell claim was sufficient probable cause depends in part on how specific and articulable it was, and an officer who later writes a report saying they detected a strong odor of marijuana emanating from the vehicle's interior has put something much more specific on paper than a vague claim made verbally in the moment. As soon as the interaction is over, whether it ended with you walking inside, with officers leaving, or with any other resolution, write down everything you remember as quickly as possible, before the specific words fade into a general impression. Voice memo, text to yourself, note on your phone, whatever is fastest and easiest for you. Memory degrades within hours in ways that feel invisible from the inside. You'll feel certain you remember exactly what was said right up until the moment you're asked about it in a formal setting, and realize the specifics are much blurrier than you thought. A note made within 20 minutes of the encounter is dramatically more accurate than a memory reconstructed 3 weeks later, and that difference matters if this ever becomes relevant in a formal proceeding. Let's spend some time on the specific scenarios where the smell claim comes up beyond the driveway encounter we opened with, because it doesn't only happen there, and the context matters. In a traffic stop, which is one of the most common settings where this phrase comes up, The smell of marijuana is often invoked as the justification for asking you to step out of the vehicle, for calling for a drug-sniffing dog, or for searching the vehicle directly. The automobile exception means that a vehicle search based on probable cause can happen without a warrant, and in jurisdictions where marijuana smell is still treated as probable cause, that claim gives the officer meaningful legal authority. In jurisdictions where it isn't, it doesn't. The response in a traffic stop setting is the same. Am I being detained? I don't consent to any search, stated clearly and calmly, creating the record, and then letting the legal question of whether that smell claim was legally sufficient get resolved in the proper setting afterward. At a pedestrian stop or on the street, if an officer approaches you walking and invokes smell as a reason to stop you, the framework is essentially the same, but the physical dynamics are different. You're not in a car, so there's no automobile exception in play, and the standard for detaining you on the street is reasonable suspicion, while the standard for searching you is probable cause. Am I being detained is the first question, same as always. If yes, I don't consent to any search, same as always. If no, walking away calmly is entirely within your rights. At home, which we opened this video talking about and which deserves the most attention, given the stakes involved, the smell claim operates in a fundamentally different legal environment than it does near a car. Your home carries Fourth Amendment protection at its highest level, and the smell claim alone does not, in almost any jurisdiction, authorize entry into your home without a warrant. An officer standing on your porch or in your driveway saying they smell something does not have the automatic legal authority to walk through your front door the way they might have legal authority to search your car in a jurisdiction that still treats smell as probable cause. The claim, if the officer wants to act on it in relation to your home, generally needs to go through a warrant first. Which brings us back to the full phrase set, am I being detained? I don't consent to any search, and I don't consent to entry into my home. Each one doing specific work in this specific context. Let's talk about the drug-sniffing dog question, because it often comes right after the smell claim, and it's connected to it in ways worth understanding. If an officer claims to smell something and calls for a K9 unit, or if one is already present, the question of whether the dog can sniff your car is legally distinct from the question of whether you can be searched. The Supreme Court has held that a dog sniff of the exterior of a vehicle during a legitimate traffic stop is not itself a search requiring probable cause. The dog walking around the outside of your car doesn't trigger the Fourth Amendment the way opening the trunk does. However, and this is genuinely important, the same court has held that officers cannot extend the duration of a traffic stop beyond the time reasonably necessary to complete its original purpose just to wait for a dog to arrive. If your traffic stop is for a broken taillight and the officer has addressed that, they cannot hold you for an additional 45 minutes waiting for a dog without independent reasonable suspicion that something else is going on. The question, again, comes back to the same phrase, am I being detained? If the stop is over, you should be free to go, and a dog sniff that happens only because you were held longer than the stop justified is itself legally problematic. Now here's something that's worth sitting with for a moment, because it's one of the more counterintuitive aspects of all of this, and I want to address it directly. None of what we've talked about in this video is about anything other than making sure the rules that exist actually apply to you the way they're supposed to. It's not about evading accountability. It's not about making law enforcement's job harder for its own sake. And it's not about assuming that every officer who claims to smell something is lying. Some officers who say they smell something genuinely smell something and are doing their job exactly as the law intends. Some are in jurisdictions where that claim still constitutes valid probable cause and are legally entitled to act on it. None of that changes what your rights are, because your rights aren't contingent on guilt or innocence, on whether the officer is right or wrong, or on what the search would or wouldn't find. Your rights exist and apply regardless of all of that, and exercising them isn't an admission of anything, a statement of distrust, or a hostile act. It's simply what the Fourth Amendment is there for. Understanding your rights well enough to exercise them calmly and correctly is not in tension with respecting law enforcement. It's actually the best version of how this system is supposed to work, with everyone playing their role correctly and the legal standards doing the work they were designed to do. Let's talk about what you do after an interaction where a search did happen, either because the officer had a valid warrant, because they claimed probable cause and proceeded over your objection, or because at some point in the conversation you said something that was treated as consent before you realized it. The first step is to get an attorney involved as quickly as possible if anything was found, if you were charged with anything, or if you believe your rights were violated during the encounter. Not tomorrow, not next week, as quickly as possible, because the attorney's ability to challenge what happened depends significantly on how quickly they're involved and how clearly the facts are preserved. If you were charged with something, do not discuss the details of what happened with anyone other than your attorney, because anything you say to other people can potentially be used against you and cannot be protected by attorney-client privilege the way conversations with your lawyer are. If you believe the search was illegal, if you clearly refused consent, if you weren't given a warrant to examine, if the smell claim was the only basis, and your state has moved away from treating that as probable cause, tell your attorney exactly this, in detail, as specifically as you can. The motion to suppress evidence obtained through an illegal search is one of the most important tools in a defense attorney's kit, and it can result in evidence being thrown out that would otherwise be the centerpiece of a prosecution. But that motion only works if the facts support it, and the facts are established by what actually happened during the encounter, documented as clearly and specifically as possible, as close in time to the encounter as possible. Let's talk about a set of related scenarios that don't involve smell specifically, but involve similar dynamics around consent and probable cause, because the same three phrases apply across all of them. If an officer claims they can see something, visible evidence of a crime in plain view, that's a different legal concept called the plain view doctrine, which allows officers to take action on evidence that's openly visible from a place they're legally allowed to be. If you're in your car and something is sitting on your passenger seat visibly, the plain view doctrine might apply. If an officer is standing on your porch and claims to see something through your window, the analysis depends on whether they were lawfully on your porch and what the visibility situation actually was. The same framework applies. Am I being detained? I don't consent to any search. I don't consent to entry into my home, stated clearly and calmly, and then let the legal question of whether plain view actually applied get resolved properly. If an officer claims that a confidential informant told them you had something, that's a probable cause claim based on informant information, which has its own legal framework around reliability and corroboration. It doesn't change your response, but it's worth knowing that informant-based probable cause claims have been challenged successfully many times on the grounds that the informant wasn't reliable, wasn't credible, or provided information that wasn't sufficiently corroborated by independent observations. Again, your consent or refusal creates the record that allows this challenge to happen. If an officer says, "It just looked suspicious," that's an attempt to invoke reasonable suspicion rather than probable cause, which is the lower standard that justifies detention, but generally not a full search. Am I being detained is still the first question, and if the answer is yes, the officer will eventually need to articulate their specific, reasonable suspicion, and "it looks suspicious," in isolation, is often not sufficient articulation when examined by a court. Let's go deeper on the home context, because I think it deserves more time than we've given it so far, and because the stakes involved are at their highest level here. Your home is the apex of Fourth Amendment protection, and the history of why it holds that position is worth knowing, because it helps the logic of the protection make sense, rather than just feeling like a rule you're supposed to follow. The framing generation of this country had lived through a period where British officials conducted what were called general warrants and writs of assistance, documents that gave officials broad, essentially unlimited authority to enter homes and search for whatever they were looking for, without any specific justification required for any specific entry. The experience of living under that regime was one of the primary motivators for the Fourth Amendment's specific language, and the protection it built around the home was a deliberate, considered response to exactly that experience. When the Fourth Amendment says there's a right against unreasonable searches and seizures, and when courts have consistently interpreted that right as being at its strongest in the home, they're honoring a very specific historical choice made by people who had experienced its absence and who wanted to make sure that absence never happened again on this side of the Atlantic. Understanding that history makes the protection feel less like a technicality and more like what it actually is, which is a fundamental structural guarantee about the relationship between individuals and government power. The government doesn't get to walk into your home because it wants to. It doesn't get to walk in because an officer has a hunch. It doesn't get to walk in because it's more convenient than going through the process of getting a warrant. A judge, reviewing evidence, applying a legal standard, making an independent decision about whether the justification is sufficient. That is the process. And the protection around your home is specifically designed to make sure that process actually happens, rather than being bypassed by the convenience of standing on your porch and asking. Let's talk about what happens at the door specifically in the smell context, because there's a version of this scenario where the officer approaches your home and makes the smell claim before you've even gotten out of your car, while you're still in the driveway. And there's another version where the claim comes after you've gotten to your door and are about to go inside. These two versions of the same scenario have slightly different legal dynamics. If the smell claim comes while you're still near your car, in your own driveway, the automobile exception may still be in play depending on your jurisdiction, and the officer may have some basis for searching the vehicle even in your own driveway, because the automobile exception doesn't disappear simply because you've parked at home. This was addressed by the Supreme Court in a 2018 case called Collins versus Virginia, which held that the automobile exception does not allow police to search a vehicle parked in the curtilage, the immediate, protected area around your home, without a warrant. The curtilage of your home, the driveway, the attached garage, the immediate yard, generally carries elevated protection compared to somewhere random on the street, and Collins specifically held that the automobile exception doesn't override that curtilage protection. So if your car is parked in your driveway or attached garage, the smell claim alone, even in a jurisdiction that still treats it as probable cause for a vehicle search, may not be sufficient without a warrant, given the curtilage protection that applies. This is one of the more specific, technical legal points in this video, and it's one genuinely worth knowing because it reflects a meaningful expansion of home-related protection that applies specifically to your vehicle when it's on your property. If the smell claim comes after you've gotten to your door, and the officer is suggesting that the smell emanating from the home itself justifies entry, you're in the clearest possible case for the protection we've been discussing. An officer's claim of smell alone does not justify entering your home without a warrant, and "I don't consent to entry into my home" is the appropriate, complete response. If the officer believes the smell gives them probable cause to search for something inside, the correct process is to go get a warrant, and saying "that's fine, I'll wait," or "I understand, please go through the appropriate process," is a completely legitimate response. Let's talk about... Before I let you go, I want to say one more time that understanding your rights clearly isn't a small thing, even when the specific topic feels minor on the surface. It's the difference between navigating a real situation with confidence and navigating it with anxiety and guesswork. And that difference matters more than people usually realize until they're actually standing inside a moment where it counts. Thanks for spending this time building that understanding with me today. I'll see you in the next one.